Are we live? Yeah, we're live. Okay, let's go ahead and go on the record on this case. Cause number DC 1917340, Fisher v. Fisher. Counsel, make your appearances.
Your Honor, my name is Seymour Roberts. I'm here with Larry Friedman. We represent Clifford Fisher, and we represent Clifford Fisher and Company, which is a company that is 50% owned by both Clifford Fisher and Gail Corder Fisher.
Your Honor, I'm Don Godwin, and I'm here joined by Carolyn Raines and Sean McCaskill, two of my partners, and we represent Gail Fisher.
Good morning, Your Honor. Alan Lowenson, and I represent two of the defendants, Larry Keel and Ted Uzelak.
We're here on a motion to seal, is that correct? Oh, Mr. Friedman, did you want to say something?
I wanted to apologize to Mr. Godwin. I noticed that he called me this morning and I had an appointment to execute new wills with my wife.
Oh.
So I just finished.
Well, I'm going to forgive you for not calling me back, Larry, so long as you have me prominently placed in that will.
I listed you as one of my sons.
Well, that means more to me than the money.
All right, well, let's get started on this. We're on a motion to seal. First off, is there any member of the public here? I don't see anyone. All right. Let's go forward with the motion to seal.
All right, thank you, Judge. As I said, my name is Seymour Roberts. I represent the company and I represent Cliff Fisher. And I want to mention, Judge, that besides the company and Cliff Fisher, the company has 5 directors, Gail and Cliff, 3 independent directors, Ivan Hoffman, Andrea Weiss, and Jim Carricker. All 3 independent directors support this motion along with Cliff. So let me go forward. We're here asking today that the court records in this case be sealed. And the basis for sealing that is Rule 76A of the Texas Rules of Civil Procedure. As you will recall, there is litigation proceeding before 2 separate tribunals. In the 254th, there is a domestic relations litigation between Cliff and Gail. This includes their divorce, which culminated in a divorce decree, and that is our Exhibit 1, which we sent over to the court. While the divorce action was proceeding, Cliff and Gail agreed that the records in that litigation should be sealed. They entered into an agreed order to seal those records, and that agreed order is our Exhibit number 2. And I want to emphasize that that was an agreed order. Now, Gail appealed the divorce decree, but Gail never filed or posted a supersedious bond, and that appeal is underway. The litigation in the 254th also includes the enforcement of the divorce decree and contempt under Chapter 9 of the Texas Family Code. Cliff and the company and Gail disagree over what is encompassed within that, but that disagreement is not relevant as to why we are here today. There's also litigation, as you well know, going on in the 68th, which is your court. Gail filed a petition against Cliff and 2 other executives of the company.
I know the history. Let me just do this. Let me hear from Mr. Godwin on, are you opposed to this?
Yes, Your Honor.
And
why? They have failed, Judge, as you know, at least as well, probably better than I, that the defendants, the movement with regard to a motion to seal, they must move the procedural as well as substantive burdens required by 76A, and they failed on both counts, Your Honor. And we ought to be able to stop after they fail on the procedural side of it. They did not post notice as they're required by law under 76A, at least 14 days before the hearing. There's no notice posted.
Well, if you're right, if that's the case, was notice posted or not?
It was not, Judge. It was not. May I finish? May I finish, Seymour?
I thought he was asking me a question.
I wanted to ask him if that was true. So let me, Mr. Roberts, was that true? Did you?
Judge, the answer is yes, but, and the but is that we are, I believe, exempt from posting because under Rule 76, A23, we ought to be exempt from posting because you don't have to post if the documents are filed in an action originally arising under the family code.
Sorry,
And-
say this again, A276, A2,
No, it is 76, I'm sorry, 76, 76A, then 2A3.
And Judge,
Now,
The-
I'm not finished.
the
For
Court of
purposes
Appeals,
of this rule, court records mean all documents of any nature filed in connection with any matter before any civil court, except documents filed in an action originally arising under the family code. And there is a tremendous amount of evidence that shows that the litigation that Gail is filing in your court arose under litigation arising in the family code. For example, if you turn to our Exhibit 4, you will see allegations made by Gail in her complaint that talk about challenges to a compensation and voting agreements. There are 6 of those agreements. She challenges a voting agreement. She alleges breaches of fiduciary duty. And if you
so
go-
let me ask you this though. That may, okay, so if this isn't a court record, then you don't have to post? Is that
That's
your
right.
argument? Okay.
Judge, that's just
And I'm
nonsense.
not finished. I'm not finished.
Well, you'll talk all day, Seymour.
Well,
May I-
let Mr. Roberts, let Mr. Godwin speak.
Judge, the rule is very clear. They've got to post at least 14 days before your honor in your court. They did not do it. It's simple to have done it. They've got to have given that same notice, posted it with the Texas Supreme Court. They didn't do it. I know very well what the rule says about an exemption when it's a family law matter. The Court of Appeals, your honor, our esteemed Court of Appeals addressed this very issue when they granted in part my petition for mandamus, when they said this case should have never been, all of it shouldn't have been taken by Judge Wasaki, and she abused her discretion by taking it, and they ordered a large part of the case, we're not here to argue today what that is, back into your honor's court. So Judge, we know that the breach of fiduciary duty case that's in your court, that's where they're wanting to seal the files in the 68th District Court. That cannot be done legally without them having properly and effectively posted, which they did not do. He can talk all day long and waste your time and mine and everybody else's, and it won't make it so.
All right, thank you, Mr. Godwin. Briefly, Mr. Roberts.
Judge, if you take a look, all right, I've told you what's in our Article 4, our Exhibit 4. If you look at Exhibit 5, you will see the very same claims that Mr. Godwin is raising in your court are the claims that Gail raised in the family court. Breaches of fiduciary duty, challenges to the compensation and changing control agreements. The very same claims that was before the family court, she raised in that action, she's now raising in your action. And the section of 76A says,
All right, thank you, Mr. Roberts. I'm going to go, I think Mr. Godwin is right about this. I think you're going to be required to post, and so we're going to need to move this hearing. I don't know if I need to deny this for now. I mean, I'm would
ask that you, Judge, your honor,
Judge,
today we're here on the motion.
continue the
I would
hearing.
ask that it be denied today and they can refile it and repost it as they should have done. I spoke with them about this. They didn't attempt to cure it. I offered to delay the hearing, put it off. Nothing was acceptable. I'd ask that it be denied
Judge,
as is filed, your honor.
in response to Mr. Godwin, let me just say that when this was heard in the 254th, because remember, we filed this first in your court, it went back to the 254th, and we heard it in the 254th, and Judge Turner granted this motion. So there was no reason to do anything else. We thought that it would be granted. Now that it's back in your court, that's fine. But I think Mr. Godwin's facts are just a little bit different than what actually happened.
Judge Turner cannot be granting a motion to seal a file in your court, Your Honor, unless they meet all the hoops. I mean, it's ridiculous to suggest otherwise.
Well,
Right,
it's
guys.
not.
Whoa. Hearing's over. Motion's denied. Mr. Godwin, if you feel like you need an order on that, it's denied without prejudice to refile. I want that in the order. So, Mr. Godwin, if you could have someone prepare that, and the motion's denied. I think you have to post, and so, and then we'll go through it and do it the right way.
Thank you, Your Honor.
All right, guys.
Thank you, Judge.
Thank you. You have a good day.
Have a good day, Judge.
All right, Mr. Mathis, Mr. Whidden, did you guys work everything out?
I think so, Judge. I would appreciate it if we could kind of read to you what we have talked about them producing to us.
Sure, give me 1 second. Okay. Yeah, go ahead and go ahead and do that and announce the name and cause number when you do that.
Okay. The cause number is DC 13-13456. The Jorge Levy Family Limited Partnership versus Jeffrey J. Gilbert. We went into a breakout room, and Randy, correct me if any of this information I'm saying is incorrect.
Okay, wait a minute. Before you start doing that, I think it would behoove everybody if you prepared a proposed written order listing these things and let me look at it before you submit it to the court. Please let me look at it first, so that Mr. Gilbert, and something happened after the breakout room and he disappeared. He's
coming back.
Is he coming back? Great. Okay. So that he hears this, but I think it ought to be in writing where there is no question about this, because we need to bring this to a conclusion.
Well, my only concern with that, Judge, is that once we start circulating orders, revisionist history takes place, and while we're all here on the record.
Yeah, I agree with you. Go ahead and announce the agreement, Mr. Mathis. You need to respond, and then if then you can submit the order to. I agree with Mr. Mathis that you should send it to him, and this will be on YouTube, so you can even go back and look at exactly what's agreed to. Be easy. You don't have to order a transcript on this unless you want to appeal it. And so go ahead, Mr. Whidden, and announce the agreement.
Okay, so with respect to the motion section 2.4B, which has to do with the cars, they have agreed to produce the titles and any loan documentation relating to the Chevy Tahoe that Mr. Gilbert owns and the Lexus SUV that Mr. Gilbert owns. As far as 2.4C of the motion goes, they have agreed to produce the Veritex account statements that we don't have starting in July of 2020 and continuing to present. For 2.4D, the guarantee bank account, they have agreed to produce the last year of bank statements and continuing. For 2.4E, which is the Remington Crescent job that Mr. Gilbert's working on, they will get the documents showing the contract that's executed, as well as documents showing how Mr. Gilbert has been paid the $155,000 or whatever portion of it he has been paid, how that was paid, where it was paid, what method of payment was used. As far as the documents in section 2.5 of the motion, they have agreed to produce the documents referenced in 2.5B, C, D, E, I, K, L, M, and N.
Okay, I don't have those in front of me. Are those how he paid the sorority fees or the tuition fees?
I will read them off to you since you don't have the motion in front of you. B is the documents showing how he pays rent for Natalie's sorority house that she lives in. C is how he pays Natalie's sorority dues. D is the $500 monthly allowance that he gives Natalie. E is the Venmo account and the statements of account and what payments he's made using Venmo and what receipts he has on Venmo. I is the allowance given to the other daughter, Catherine, in 2019 and 2020. L is how he has paid his rent, and I think we talked about since March. I don't have that information. So from April to present. M is the Glen Meadow job that he testified he worked on in 2019 and 2020, and the $75,000 he received. So the contract and all the payments. And N, as in Nancy, is the Shenandoah job, which is the other construction job he testified he worked on, and whatever money he received for it and the documents that support that.
Is that agreed to?
Yes.
Great. All right, guys, just get me an order as soon as possible. It'd be great to get it before Friday and email that to my court coordinator and e-file it.
Okay.
Thank you very much.
Thank you, guys.
Okay, thank you, John. Thank you.
Okay. Tony, we're done for today. So we'll reconvene on Friday morning. And Ashley, we have the thing at 11 on Thursday. Just remember that. Tara and Megan, we'll see you in a few minutes. And Rhonda, call me if you need me this afternoon. Anything we need to chat about before I turn this off?
Oh wait, Judge Hoffman, because I'll be there in just like a few minutes. How many people should I say the table is for?
4.
4? Okay. Thank you very much.
Okay.
Bye.
Bye,
Bye,
guys.
y'all.
All right, I'll see you in a little bit.